There is an exception for emergencies, and that would be an emergency. Emergency would be any kind of natural disaster like that, and you can dispense with all notice in that circumstance. I mean, you can have your meeting and proceed to do what you have to do. But most of the time, again, if we're not in that kind of emergency situation, your notice includes three things: the time of the meeting, the place of the meeting, and the business to be transacted. And the business to be transacted is important because you can't take final action on anything that isn't listed in the notice for the meeting. Okay, probably, I'm sure you're aware of that, but that's the important point on your notice. Be sure whatever you may be deciding, you get listed in the notice. And you can have as many topics as you want. There's some I think, misconception that a special meeting can only cover one topic. But as long as you list it in the business to be transacted, you can cover as many topics as you want. There is an exception for emergencies, and you can't take final action unless it's listed in the notice. I won't go into this very much, except to note the county commissioners are to hold their regular meetings at the county seat, but you can hold special meetings outside the county seat. And this, too, is somewhat on procedure, and I'll go through this fairly fast, but the question does come up about adjourning a meeting, which the way the Act uses the term, it's really continuing a meeting, or if you know you don't have a quorum in advance of a meeting, I get the question, do we have to hold the meeting? Do we have to have somebody go down there, even though we know no one's going to be there? You just need to post notice on the door outside the meeting room chambers that the meeting has either been canceled or will be continued to the next night or the next day. And then any absent members, if the decision has been made not to have a meeting, just notify them. Again, that's kind of technical. I thought it would be helpful to have in your packet, but I don't know how long we really want to spend on that. I don't know how you could decide not to have a meeting if you couldn't talk to each other. So that is one exception, I think, to the rule. You have to be able to talk to each other and decide you're not going to have a meeting. And actually, that applies to calling a special meeting. Since a majority of the governing body can call a special meeting, so two of you can call a special meeting, you have to be able to talk to each other to decide you need a special meeting. So that is an exception to the rule. I just think it doesn't make sense otherwise. So. Now, minutes have to be kept of all regular and special meetings, but they're not required, and I would not recommend that you keep minutes of executive sessions. And we'll move to executive sessions in a minute, because that's the other big piece of the Open Meetings Act. And then the minutes of the meeting are to be promptly recorded, and they're open for public inspection. Of course, minutes are a public record that any citizen can have access to. So even if they're not at the meeting, they can find out what happened. Okay, let's move to executive sessions, because the other big piece of the Open Meetings Act, it does allow in certain limited circumstances that the governing body can go into executive session to discuss items. And what executive session means is it's closed to the public. That's what an executive session is. It is always done as part of a regular or a special meeting, although you may just open the meeting, go into executive session, come out of executive session, close the meeting, but it is done as part of a meeting, either a regular or a special meeting. And the people who are entitled to go, the only people automatically entitled to go, are the body themselves, county commissioners in this case, or whoever the body is. Anybody else is by invitation, with one exception relating to litigation. But they can invite other people in. They can have specific staff members come into the executive session, or there may be a purpose for a citizen even to go into an executive session. But they are meant to be confidential. They're closed generally to the public. The attorney has to be present if they're going to talk about litigation. That's the one time that someone else has to be in the executive session, or it's not a proper executive session. There is definitely a presumption that the governing body may, in certain circumstances, need other members of the staff or the public to come in and provide information, and that is universally done by governing bodies across the state and has been for a long time. And I think the fact that there's no court case that says they can't is more telling, because I think the presumption in the Act is that they could invite the public in. Now, it doesn't change the confidentiality of it. It is still a confidential meeting, and everybody has to preserve that confidentiality. But there may be circumstances where the purpose of the meeting would necessitate some other person being there. So there's not a court case that says it, but I'm very comfortable that that is the way it works. And there's a number of reasons for an executive session. Litigation is only one of them. So sometimes it's to discuss real estate transactions. That's one of the other ones. So you might have somebody in there who's involved with that. That's the issue, I think. And I'm comfortable that you can.
You invite staff into an executive
Yeah, you can have staff on occasion too, because they're providing information they may need to do what they're doing. But again, it doesn't take away from the confidentiality. It doesn't destroy that. Yeah, the presumption in an executive session is that what's discussed is confidential. You don't take minutes and you don't tape record it or anything like that. You can keep private notes for your own use, and those have been held not to be public records, but that's a very limited exception. But potentially, I actually think it does violate a state statute. There is a state statute that says public officers are not to disclose confidential information learned by reason of their position, and there's penalties that go with it. And actually, I don't think it's an issue here, but that has become an issue in some jurisdictions where information in executive session is taken out of executive session, in some cases even disclosed to the media, I think, and there potentially are sanctions for that. It is meant to be confidential. The Open Meetings Act itself doesn't have a sanction, although the whole presumption is that it's confidential, but this other provision does apply to public officers, and I think arguably it would apply. Okay, I'll go through a few of the reasons. There's a list in the state statute, RCW, no, I forgot it, 4230-130, I think. I don't know if I wrote it down. Anyway, there's a list of about 10 or 11 exceptions, reasons you can go into executive session. The purchase or lease of real property where disclosure might affect the price, or the flip side, if you're selling county property and you want to consider a minimum price for sale or lease, I think, or those are two of the reasons, maybe more common reasons, that you could go in executive session. To receive and evaluate a complaint or charge against an officer or employee, this is another reason you could go in executive session. Although note that this has a clause at the end of that exemption that if the officer or employee requests it, then the complaint or charge is to be heard in an open meeting. So there is a little bit of a limitation on that. You can evaluate qualifications of job applicants and review employee or officer performance. That could be one of the more common ones. I won't go into all the details of this, but you've got the information there. If there's a vacancy on a county elective office, you can go into executive session to discuss the candidates, but notice you can't interview in a closed session, and you can't vote to fill the position in an open session. And the biggest one, probably the most common one, is this litigation. You can go in executive session to discuss litigation or potential litigation or an enforcement action being taken by the county. But notice it has to be with legal counsel. This is one circumstance, by the way, where I think this use of speakerphone could be effective for financial reasons. If you have a special case and it may involve you've got special counsel located in some other city, and you want to go in executive session to discuss that case, I think you could have that person, the attorney, connect by speakerphone. As long as they're properly connected, that constitutes presence at the meeting, and it satisfies the statute and saves you a lot of money paying their expenses driving back and forth. So that's one place where technology, I think, can be helpful here in a practical way. And then this also, again, it's not just litigation that's been filed and is pending before the county. It is potential litigation. That's not unlimited, but there is a definition there too about potential litigation. It needs to be specifically threatened, that you reasonably believe will be commenced, or there's legal risks of proposed action or on your current practice. So that's probably, I would guess, would be the biggest exception to when, or the biggest reason you would be meeting an executive session. Any vote on whether to expend funds. You couldn't expend funds without some kind of final action being taken. So, well, a discussion, if it falls into the litigation or potential litigation involving a public officer, I'd have to think about that, whether a recall against an individual, well, it's use of public funds, but the statute specifically allows that if the governing body votes to approve that. I am clear the vote would have to be done in an open meeting. I have no doubt about that. But the discussion, whether that constitutes an action that falls under litigation, I'd have to research that. It's a good question. The one I missed that I kind of wanted to spend a minute on was this, go back, or I won't go back, but there's one on procedures, and this is just kind of review of it. When you're going to go into executive session, the presiding officer is supposed to announce the purpose of the executive session and the approximate time that it's going to end. And we usually say the purpose of the executive session should be announced specifically enough so that it shows it fits the reason for the executive session, but you don't have to disclose so much detail that you're giving out information that might be considered confidential about the session. I'll give you an example. If the action involves a complaint or charge against an officer, we would recommend that the commission say, you couldn't just say it's a personnel action, because some personnel actions fit executive sessions and some do not. So you have to be more specific than that. But you could say, I would use the language in the statutes as your announcement, that it's going to be a complaint or charge against a public officer. But then as far as more detail than you need to disclose, I don't think you'd have to say this involves a sexual harassment charge against the public works director or something like that. You don't have to bring it down to the level that you disclose the details or any specific information. It has to be specific enough so it shows that it fits the executive session purpose. So anyway, there's a medium ground there, in my opinion, that satisfies the law and also does not disclose confidential information.